Tonight, I'm not telling you a ghost story. I'm telling you the kind of story that makes a country feel haunted. Because in the middle of a crowded American city, a high-profile killing turned into a nationwide obsession, and then into something even heavier, a legal fight over the death penalty. A fight that isn't just about one defendant. It's about the government's biggest punishment, the public's loudest opinions, and the quiet, procedural machinery inside a courtroom that decides what justice is allowed to look like. This is the story of Luigi Mangione and the prosecution that federal authorities say could end in a capital trial. But tonight, we're doing it carefully. We're separating what's verified from what's rumored. We're tracking what court filings actually say. And we're asking the question that matters most. When a case becomes a spectacle, can a trial still be fair? This is the death penalty battle. Before we begin, two important notes. First, Luigi Mangione is accused, not convicted. Everything discussed here is based on public court proceedings and mainstream reporting, and guilt is not presumed. Second, I'm not going to describe violence in a how-to way. This is a legal timeline and public context breakdown, not sensational content. Now, let's go step by step. In public reporting, the case centers on the killing of UnitedHealthcare CEO Brian Thompson in December 2024 in Midtown Manhattan, according to federal allegations reported by Reuters and others. From the start, this wasn't treated like an ordinary homicide, because the victim was not only high profile, but tied to a sector that millions of Americans interact with in deeply emotional ways: health insurance. And when a case touches a nerve that big, it doesn't remain just a case. It becomes a symbol. It becomes a battlefield for people's anger, fear, and politics. And then, almost immediately, it becomes content. Clips, posts, edits, arguments. People don't just watch, they pick sides. But inside the legal system, sides don't matter. Evidence does, procedure does. And the timeline, what can be proven and when, matters more than any viral opinion. So let's keep this disciplined. There is the state case, which involves New York charges. And there is the federal case, which is where the death penalty question lives. Mangione, according to reporting, faces federal murder, stalking, and weapons-related charges, and also separate state murder charges. And that split matters because the death penalty is not available under New York state law the way it is under federal law. So the center of gravity becomes federal court, and that is where the next chapter begins. Here's where many people get confused. They hear murder case and assume it's one courtroom, one judge, one trial, one outcome. But in the United States, when conduct allegedly violates both state and federal law, the defendant can face parallel cases. Think of it like two different systems looking at the same event through two different legal lenses. The state system asks, did this violate New York criminal law? The federal system asks, did this violate federal statutes? And if so, do any of those statutes authorize capital punishment? Reuters has reported that, in this case, only one federal count is the one that could expose Mangione to the death penalty, described as a charge involving murder with a firearm. That distinction is huge, because it means the death penalty fight is not a vague debate. It's a targeted legal war over whether the indictment properly supports that capital-eligible count, whether the government can legally seek death at all, and whether the process has been prejudiced by publicity. In court, these fights don't look like movies. They look like filings, motions, technical language, arguments about what words in a statute mean and whether the government met its burden. But the stakes are life and death. And because the stakes are that high, the timeline becomes even more important. Let's be precise about what it means when federal prosecutors seek the death penalty. It does not mean a person is already sentenced. It means the government is formally telling the court, if there is a conviction on a capital-eligible count, we intend to pursue the most extreme sentence. In April 2025, the U.S. Department of Justice publicly stated that Attorney General Pamela Bondi directed prosecutors to seek the death penalty in Mangione's case. And later that month, Reuters reported prosecutors filed a formal notice of intent to seek the death penalty. Those two steps matter because the federal death penalty is not casual. It requires layers of approval and procedure. When the government files that notice, the case shifts into a different gear. More complex litigation, specialized requirements, extended timelines, and a heightened focus on jury selection. Because in a capital case, the jury isn't just deciding guilt, they may also decide sentence. And that adds a whole second trial inside the trial. So when you hear death penalty fight, what you're really hearing is a fight over whether this case becomes a capital case at all. And that fight is happening now. Now we enter the courtroom chess match. According to Reuters, Mangione's lawyers are pushing to block the death penalty and argue prosecutors did not meet legal criteria for the capital eligible charge, while also raising constitutional concerns. Let's break down what those arguments generally try to do. 1. Attack the legal foundation. The defense can argue the indictment is defective, the facts alleged do not meet the legal threshold for capital eligibility, or the statute is being applied improperly. This isn't about emotion, it's about legal definitions. 2. Argue unfair prejudice and due process problems. In high publicity cases, defense teams often argue that certain pretrial conduct, official statements, or media spectacle has poisoned the jury pool, and they may seek remedies, limits on public statements, venue considerations, exclusion of certain evidence, or in rare cases, barring the death penalty entirely if due process is irreparably compromised. 3. Challenge evidence. Another recurring battlefield is evidence. What was lawfully collected, what should be excluded, what is reliable, and what is prejudicial. Because in a case like this, the story people think they know online may not be the story the jury is allowed to hear. Court is not social media, court is rules, and every side fights to shape what the jury can legally consider. Now we talk about the part everyone feels. The why is everyone talking about this part? High-profile cases pull attention for 3 reasons. 1. The victim is prominent. 2. The allegations are shocking. 3. The case touches a national nerve. This one hits all 3. And when a case becomes a symbol, people start projecting meaning onto it. They don't just ask, what happened? They ask, what does it represent? Some people will see it as a story about crime and punishment. Some will see it through politics. Some will see it through anger at institutions. Some will see it as a morality play. But the courtroom can't sentence symbols. It sentences people based on evidence. And that collision between symbolic obsession and procedural law is exactly what makes capital cases so volatile. Because if the public is screaming, the court has to whisper. That's how justice is supposed to work. And if it can't whisper, if the environment is too contaminated, then fairness becomes harder to guarantee. So the system responds with process, hearings, motions, scheduling, and careful language. Which brings us to the most important question for your viewers. What happens next? As of early January 2026, Reuters reported Mangione was scheduled to appear in federal court for a hearing focused on the death penalty issue, with the case still pending and no final resolution on capital eligibility yet. Other mainstream reporting, including AP coverage syndicated widely, has indicated the judge was weighing whether the case proceeds as a capital trial and discussing potential trial windows. From here, a few paths are possible. Outcome A, death penalty stays on the table. If the court allows prosecutors to pursue death, the case typically becomes longer and more complex. Extended jury selection, more litigation, more expert evidence, more appeals down the line if convicted. Outcome B, death penalty is removed from the federal case. If the court bars death, the case can still be federal and still be extremely serious, potentially life imprisonment if convicted, but the capital structure changes. Outcome C, some charges change, but the case continues, Bob. Sometimes judges dismiss specific counts, or the government revises, or the focus shifts. But the core point is, even when the public thinks the story is already written, court procedure keeps rewriting the boundaries. Because the trial isn't a recap, it's a test. And that test happens slowly. So tonight, the nightmare isn't a monster in the hallway. It's the idea that reality can become entertainment before it becomes truth. It's the way a case can turn into a frenzy, while the courtroom still has to measure every word. And if this really does become a capital trial, the question won't just be, what happened? it will be, can the justice system hold steady when the whole internet is pushing it to fall? Next time, I'll follow the court filings, the hearing outcomes, and what they mean, without the noise. Because here in this channel, we don't chase rumors, we chase the shadows where the facts are hiding. If you want to be updated on this, please, it takes nothing to subscribe. Like and drop your comments in the comment section.